An order stopping the All Progressives Congress from holding its convention has been set aside on the basis that a party member cannot sue the party. The issue of the court injunction has been controversial among party members and, most importantly, governors as to whether APC will still hold its convention. Now, the chairman of the Caretaker Convention Committee and governor of Yobe State, Mai Malabuni, had been accused by the governors, led by governor of Kaduna State, Nasiru El-Rufai, of keeping the court injunction under wraps until 3 days to the election convention, when it would have been too late to vacate the court judgment.
All right, for more on this, let's bring in lawyer and senior advocate of Nigeria, who's joining us, ADEYINKA Olumide-FUSIKA, and ARISE Analyst Frank Tietie. Let me begin with senior advocate of Nigeria. Well, let's talk about this court ruling. Let me just put this way so that it's clear that the 1999 Constitution in 66, 137 and 182 already stipulates that appointees of government seeking to contest elections were only to resign at least 30 days to the date of the election. What the electoral law section 8412 prescribes, is it in tandem or otherwise with the Nigerian Constitution? Senior advocate of Nigeria, FUSIKA. It seems we lost. Okay, let me, Tietie.
Well,
I'm sure you heard that question.
I did, and that is not the end of the story with regards to Section 84, subsection 12, because the powers of the National Assembly to make laws for the good government of Nigeria, and with particular reference to issues, the items listed on the exclusive list of the Constitution, it's clear the National Assembly is able, particularly under Article 22 of the exclusive list, to make laws with regards to elections in Nigeria, and the conduct of political parties and all of that fall within elections that are to be conducted for the federal, state, and the councils of the FCT. So it's not just easy to say that Section 66, subsection 1F has already made provisions as to disqualification of candidates, but the powers of the National Assembly in Section 1 and Section 4, subsection 2 are clear to the extent that it can make laws with regards to any matter listed in the exclusive list, which includes election. So the issue with regards to 30 days, and if you look at Section 84 clearly, it's even talking with specific reference to political parties, congresses, and other internal elections that are to be taking place in the political party, and not necessarily the general elections. But with those sections that are referred to in the judgment being from emanating from the Federal High Court, are sections specifically directly at the general election. So I think that is not the end of the whole imbroglio.
It's beginning to look like a very thin line between politics and the law in this matter. But we do hear senior advocate of Nigeria, FUSIKA, can now hear us. And let me begin by asking you the question posed by Ngozi earlier, because the court seems to have aligned with President Muhammadu Buhari. Is there a conflict between Section 84, subsection 12 of the Electoral Act and the 1999 Constitution, as cited by the judge, even though we have not seen a copy of the judgment yet? But those reports from court said the judge cited Section 66, 107, 137, and 182.
Well, all we have about the judgment is what we've read in the social media, that the judgment was given. So until we see a copy of the judgment to digest it, it will be difficult to really analyze it fully. But be that as it may, I would like to just say that the way things are going in the country now, the judicial arm of government being dragged into politics, I won't be surprised if by Monday another court somewhere gives a contrary order. What you have are politicians trying to use the courts to further their own personal ambition and goals. It would be interesting to know, for instance, when was this case filed? Because some few days ago, the Attorney General said they were going to find a solution, and then just suddenly this came out today. It's a very dangerous thing that we've been on this path for some time, and those of us with stakes in this system are worried about what is going on. The Constitution did provide, it provides that for people holding public offices, you must resign within 30 days to an election. The provision of the Electoral Act that we are talking about is talking about party congresses and so on and so forth. In other words, to participate in the nomination processes. The Constitution is talking about contest into the office itself, not party, whatever. Of course, there's a school of thought that says before you can become a candidate in the election proper, you must have scaled the hurdle of the party congresses and so on and so forth. And therefore, that this provision of the Electoral Act seems to be in conflict with this provision of the Constitution. I say today that it is difficult to know what the law is in Nigeria. And that's a sad thing. That's something to say about the state of our law. It's difficult to know what the law is in Nigeria because the way the courts are churning out these decisions contradictorily. You cannot advise. If I have a client now and he asks me a question about this, it will be very difficult for me to say, okay, this is what the law is. This is how you should proceed, or this is how you should conduct your affairs. This is how you should behave. It's impossible. Those people making laws are making it not in the... They really don't bother about the interest of the country. They made the law because they feel that they are at a disadvantage. I mean, members of the National Assembly who pushed this thing through, they felt that they were at a disadvantage in the political...
Okay, let me bring it back to Frank Tietie here. I mean, you just raised some very, very vital points there. Frank, I mean, you heard what the senior advocate said. First off, his last point, that those who make laws don't necessarily make the laws in the interest of the nation or governance, but, you know, for more inclined interests. Now, and he also raised the fact that the rule of law is not necessarily the guiding principle when lawmakers or politically exposed persons, you know, come up with laws or even policies. What do you have to say about that? And his point that the judiciary is treading on very dangerous ground, being pulled into politics.
The truth about it is that we have a constitution that is supposed to be a foundational law. It does not, foresee all the possibilities that can happen to the areas that it has pronounced regulations upon. That's why you have, after the Constitution, you have laws made by the National Assembly, and then those laws are interpreted when there is a conflict by the courts. And then you also have regulations that are made by members of the executive. Now, there is a reason why you have, before every election, you have a new Electoral Act. Because preceding that Electoral Act, certain problems may have been observed, certain improvements must have been considered to be made in the subsequent election, and that's the reason why you have a new Electoral Act. So when an Electoral Act now comes on board to say that, to modify the time that it precedes for government appointees to resign before the contest for election, there is a reason, definitely. And then the National Assembly is now smart to make the distinction that we are not referring to the election into the office of the president or the members of the state or National Assembly, but they are referring to internal democracies of political parties, and they extended the time from 30 days to the 3 months. Now, the idea is that so that they can prevent this internal party politics that will be vitriolic, and not only that, to prevent the abuse of executive powers to the extent that the people will be in office and then use that to oppress other contestants who are not in office, who don't have the such kind of paraphernalia of the office to contest elections. So to provide a level playing ground for them. In that case, the National Assembly has made that law in the interest of a smooth running process for electoral conduct of election in Nigeria. It is not, I don't think, in fairness to the National Assembly, that is in any way inclined to any form of self-interest.
Okay. Senior Advocate, back to you, and I have a couple of questions to ask you. What are the options left now for the National Assembly? Because you recall that when the president sent it back, they had voted against it, and now the court has sided with the president. What are the options left to the National Assembly? I also want to ask, can the court actually order for a section of a law to be deleted without affecting the entire law? Can that be done? And finally, are political appointees public servants? Because there's the argument to say the Constitution provides for public servants and not political appointees. So help us clear those issues very briefly if you can, Senior Advocate.
Well, to the first question, I think that in my earlier intervention, I've made mention of the fact that by Monday or Tuesday, unfortunately, since the courts are available to be used for these purposes, a different faction of the ruling class may get another pliable judge that will make a contrary order. We've seen this happen over and over again, and there's no reason to doubt that it's likely to happen again in this instance. In other words, the Attorney General of the Federation, who really is both the plaintiff and the defendant in this suit, that's what most people believe, has gotten his own order. He is interested in contesting. He doesn't want to resign. He's interested in contesting governorship of some states. He's not interested in resigning before early enough, and he has gotten this order. So all these moves are just personal. The National Assembly members too, who have their own interest trying to protect, would also go and get, may also go and get their own order. And for my colleague who is on this program and said something about the thing being in the interest of the people, I don't see how these people have been acting in the interest. It's always been selfish. They're acting in their own interest. They're not making laws for the good. They are making laws for them targeted at each other.
All right, thank you so much, ADEYINKA OLUMIDE-FUSIKA, Senior Advocate of Nigeria, and Frank Tietie, ARISE News Analyst. Thank you both, gentlemen, for helping us understand this. The debate definitely continues.